Well, Mr. Payne, you've developed your submission at some length this morning. If you want another 10 minutes, you can have it, but I don't think I can give you any more than that.
My Lord, I'm not going to develop the submissions anymore, I think. At this
Sorry?
I'm not going to develop the submissions anymore at this stage.
Right.
Can I just, in light of my Lord's question about whether the police were seeking a quashing order or quashing order and wouldn't object to the court doing another order, if I can just provide an update in relation to the matter, which is insofar as the judge's order is quashed and consideration is given as to how to go forwards. In light of the new technology the police have available to it, the police confirm that they will be able to arrange an interview by the 12th of November.
If the order is quashed, is that what you said?
Yes. Yes, and so if the order was quashed and then the court was considering for itself, what would be the appropriate order to make. The police's position is that the interview can be and will be arranged prior to the 12th of November.
12th.
Yeah.
And the fact-finding hearing was on the
29th.
29th.
So including the 12th. Yeah, so when I say prior to the 12th, I'm including the 12th.
So if that were to happen, would there be an objection to disclosing the material on the phone or on the hard drive to EM on the basis that it would not be disclosed any further to the parties
until the interview's been
until the interview's taken place?
No.
Right.
So EM can get on and download, do their schedules or whatever it is in advance of the interview, but it can't go to anybody else.
Until the interview's been completed.
Until the interview.
So a hard drive, sorry to be certain of this, Mr. Payne, a hard drive could be disclosed to EM now or
well, whenever, as soon as we can.
Quickly, within the next.
I've tried to get instructions, but
without boring now, but it could. It's not going to be a long delay.
No, because it's now being done by another police force. But yeah.
Okay. On the basis of not disclosed till after the interviews.
That's right, and just for rationality purposes, given the nature of the challenge the police have advanced, the reason why the police are content to do that is because the material has now been reviewed. So in terms of any inspection, the police have had the opportunity to consider the material that's being provided to EM. Yeah, in contrast to the situation at the time of the hearing, when significant portions of the material hadn't been reviewed.
Right.
So if it's now been reviewed, we're the 12th. So that's fortnight tomorrow.
That's right.
Within the next 14 days, you will be interviewing.
Well, we will arrange an interview.
Yeah. All right.
So
can I just flag one thing up? I mean, clearly, whether the parents attend the interview is something outside the police control. Now, if the court wishes to provide a direction in terms of attendance to the interview, then that's something for the court to consider.
I don't think we have power to do that, do we?
Well, they are parties to the proceedings.
I'm sure that we can, and I have no idea what the parents do, whether they're at work, whether they're...
All we can do is arrange the interview.
Yes. All right. Yes, Mr. Sampson.
We'll deal with the practicalities first. My learner friend was kind enough.
I'm sorry?
Forgive me, I can take that off now.
Yes, you can.
Also found it. Dealing with the practicalities first. My learner friend was kind enough to tell me what he's just told this court, and just as my lords came back here. It is happy news to us, because a week ago, my instructing solicitor asked the police legal department whether the timescales were still as they were stated in the officer's open statement, which was interviewed in December, and we were told that was still the timescale that they were working with. So that is a new development. I'm putting some flesh on the bones. It strikes me, my lords, subject to my learned friend's views, that means that within a matter of a day or two, i.e. by next Monday, EM could have the data. There had already been agreement reached subsequent to the hearing on the 23rd that the police would arrange for EM to bring a second hard drive and will put the data onto that. So we have the mechanics already in place. and they are still working to the timescales they were, which is 10 to 14 days. And I can see that there should still be the sort of order that previously there was, which is one that effectively prohibits its disclosure by the local authority, which is the lead solicitor, to any other party, and that indeed would be the normal way with bipartite disclosure to local authority first by police and then to the other parties, and no other party raised an objection to that.
Well, do you want 5 or 10 minutes to talk amongst yourselves and see if this will dispose of the appeal?
It couldn't be done any sooner in any event now. That is the point my learned friend's saying, which is, as I understand it, they will make that available within a matter of days. What he hasn't yet been able to take instructions from is a further development, which is helpful, which is that, as my lords have heard, this has been outsourced, in fact, to another police department, another police force, forgive me, and they are still waiting on an answer from that police force to see whether or not they could, in fact, themselves provide the data that we need.
Thereby obviating the need to involve EM at all.
Quite so. And the
Which
cost.
would presumably save money.
Yes. Because EM is, as my lady now sees, simply the vehicle by which we get this data in accessible form. It is no different, dare I say, without any disrespect to them, to what the police high-tech crime unit will do.
Well, do you want some time, all of you,
right.
to see whether this disposes of the appeal? I mean, if there's an agreed timetable and procedure.
Well, my lord, we would want this appeal determined because the issues that have been raised are important from the perspective of my client because this is an approach which, albeit because of the pressure of court time, which has been regularly encountered, and any guidance this court can give us to the proper, reminding the courts as to the proper approach and the issues that need to be considered, it'd be very important to my client, and it's why the expense has been incurred in part in appealing this case, this decision. So even if you were to find that the order is flawed and quash the order, and in terms of practicalities, the subsequent order is easy for this court to make, we would nevertheless like a conclusion from this court on the merits of the order that was made and the reasons that were provided.
Well, on one view, if you agree an order, the appeal is academic. And a decision of a circuit judge in the family court carries very little weight in terms of precedent value.
That I can accept, my lord, but the judgment of the Court of Appeal reminding courts as to the process and the importance and significance.
Yeah, but we're here to decide disputes, not to give advice to the profession.
Absolutely, my lord, but there is an outstanding order from the court, and until that's quashed, that remains a binding order.
Lord, I would say this is perhaps not the case to use for this reason, and it's the point that my lady observed earlier. The order for disclosure of this material was made at the end of October of last year. The order that, which time I wasn't involved, but the order that was made on the 20th of August, and I accept with the benefit of hindsight, given that no party had applied to enforce that order, and nor had the police applied to vary or discharge that order, and they had, as I said to my lords in our skeleton argument, in fact completed the Annex D form under the 2000 protocol, saying that that wasn't something over which objection was raised, rather it was a matter of timing. They hadn't yet got round to interrogating the material. That the order that Her Honour Judge Walker made in August of 2021 was a consequence of the earlier disclosure order, which still stood. The only difference was this, that the first order provided for disclosure of the data from those phones. The second order, because by that time we knew we couldn't get that, provided for a mechanism by which we could get it. Yes. But my learned friend has properly conceded the point that the phone, as effectively a hard drive with apps on, is simply, falls within, forgive me, practice direction 31B of the CPRs. And thus, it was doing no more than providing a mechanism by which the earlier disclosure order was delayed. And so I do question whether or not this case is an appropriate precedent. I also draw my Lord's attention to an observation made by this court earlier, which is that these were not phones, and this is wrong in the open statement, that had been seized. It was open for these parents to request these phones back. And although my Lord's having raised this point, we didn't include it within the authorities bundle. There is, in fact, and my Lords may have had this in mind, an authority from 1992 called Marcel and others and the Commissioner
Yes.
of Police, in which precisely that point was raised.
Yeah, no, I read that in advance of this appeal.
Yes. So well, for my part, I would like 5 minutes. I would like to see if we can actually keep a case that needs urgently to be heard on track at the end of November, rather than be occupied with dealing with this. But if I do need to deal with matters, my lord, my lady, having considered that,
Yeah.
I will address briefly the ground one raised.
Do your co-respondents agree with that?
My lord, we would certainly support having some time to consider the matter. We literally were just given that information before your lordship and
Yeah.
your ladyship came into court.
So it's a yes, but.
Yes, but
And what's the but? You want more than 5 minutes?
we will be swift.
I'm sorry?
We will be swift. So perhaps 5 or possibly 10 minutes.
10 minutes, all right,
I would
yes.
just like the opportunity of speaking to the client.
Yeah,
Overwhelmingly yes. 5 minutes, please.
right.
My lords, may I forgive you? May I also indicate on behalf of the local authority, having heard the exchanges between my lords, my lady, and my learned friend, that the aspect of ground one relating to the closed statement, it wasn't an application that I made, is one that I'm happy to concede.
Right, thank you very much. We'll be back in 10 minutes.
Should we just have a word outside?
Can I butt in? Sometimes we're in a closed group, the Guardian. Sometimes we're not. It's going to help us prepare the fact file if we have the document. Just step back.
Oh, yeah.
Is that basically an invitation to the bench to quash the parts of the order that provide the disclosure? Okay.
Right, what progress, Mr. Simpson?
My Lord, thank you. I've been endeavouring, my friend has without success, to contact our instructing solicitor. The lady who attends with us today is from the legal department, but doesn't have conduct. But, my Lord, in relation to the position the local authority adopts, I'm content to press forward with the way in which I put the case shortly before we left, which is that we would invite the police to provide that and look to them to agree an order today.
Sorry, just say that again,
Yes.
police.
The police to provide the data on a second hard drive to EM by Monday of next week. If in the meantime they are, as my
That's the first of November.
Yes, and that effectively, because my lady, this case starts on the 29th, and it's then heard split over 3 weeks.
Yeah.
That gives us a relatively short time frame, but it means, all being well, that we will then have the calendar up, the report back in by the 15th of November, which is 2 weeks before this case is due to start. I know that my learned friends have done what they can to see if they can get, in fact, what we would be getting from their colleagues in the other police force.
So, just to go back to the beginning, police to provide the data by Monday the 1st of November to EM and to the local authority, or just to EM?
Well, as I'm working, forgive me, I'm not being obtuse about this, there are 2 ways forward, one of which is that we get a hard drive that tells us nothing, and we need to send it to EM for them to digest it over 2 weeks. The other is that this police force can, through their colleagues, get what we would otherwise get from EM. I don't know when they could get that to us, and what I suggested to my learned friend earlier was that if it can be earlier than the 15th, then it can at the very least be provided to the local authority. And as I mentioned to my Lord earlier, under the bipartite disclosure rules, we will be entitled to have that anyway, and the issue would then be when the other parties receive it.
Yeah.
I know that my learned friend Mr. Day, on behalf of the child, has raised the alternative that there is a provision in the order for disclosure to the advocates only, and I will leave him to address my Lord on that. I'm afraid purely selfishly, my interest is in ensuring that this is known to those who instruct me and being able to take instructions. But my Lord, either way, that means that we, with a following wind, have 2 weeks to prepare this case before it starts on the 29th. In relation to the appeal itself...
Before you do that, with suitable confidentiality undertakings.
Certainly, yes. My lady heard earlier, my lords, that there is also an order that provides for disclosure of other material, very much in line with the decision of Mrs. Justice Knowles and her colleague Mr. Justice Francis, whose 2 cases provide guidance to practitioners from 2017 and 18. And I note and I accept entirely that not all of that guidance was followed either by this local authority, by the parties, or indeed by the police. And lessons are to be learned. I query whether or not this is the case for the Court of Appeal to involve itself, but certainly I will speak to any issues my lords and my lady have.
Yeah. All right. Ms. Meachin, what's your position?
Our position has been that we have been able to speak with the father and our instructing solicitor, who are following proceedings but from the solicitor's offices. As far as the father is concerned, he is perfectly content to make himself available for any interview, and we are endeavouring to make inquiries of the mother through her solicitor. He, of course, notes that effectively we are going to be under certain time constraints in order to do as he would wish us to do, which is to use this time for the fact-finding effectively. I was attempting to query with my learned friends before we came back into court what effectively this means in terms of the application that the police have made, where they are maintaining their position and wish to pursue ground 1, and in which they submit that the judge carried out a flawed exercise, which we wholeheartedly reject on behalf of the father.
Well, what's being proposed is a different mechanism for getting this material before the family court.
We have no difficulty in following a pragmatic route.
Right.
That was effectively what the judge in the family court sought to do.
Yeah.
And of course, one of the matters that we set out in our skeleton argument was that we questioned the route that the police were taking by this application for permission and the appeal, because as their own police representative made the point in the hearing, they were alive that they could come back and apply to vary.
Yes, well, I mean, I don't want to go through the grounds of appeal now. I'm interested in whether the pragmatic solution that has been put before the court half an hour ago, 20 minutes ago, is one that your client can accept. And it sounds as though the answer is yes.
It is a yes, understanding, if we may, what the legal framework will be, bearing in mind that my learned friend on behalf of the police has indicated that he wishes to pursue his appeal in relation to ground one.
If there is a pragmatic solution which everybody agrees, then I think our provisional view is that the appeal is academic and this is not a suitable occasion for giving gratuitous advice to the profession.
My lord, yes. Our only concern was, of course, to be able to uphold the decision of a hard-working, hard-pressed judge in the local court.
Well, that's as maybe, but what's being proposed is a variation of the order that she made,
yes,
which would provide a pragmatic solution, and her amour propre doesn't really come into it.
yes. We're quite content.
Right. Yes, Mr. Day.
My lord, my simple mandate in this case has been to make sure the fact-finding goes ahead, and this is a way. There's going to be pressure on the advocates for the trial, but certainly we have 2 weeks, and we've all worked under those constraints before. So I'm pleased to say I've contacted the Guardian and indicated that that is the development. And if we have that material, and the only thing I have raised, and it's covered in my skeleton argument, I've referred to a principle that's referred to in family law as the official solicitor in K, which may not mean anything to my lord and my lady, but it's a simple mechanism whereby advocates are entitled to documents on an undertaking. They won't disclose their contents to their client. Might mean that the lawyers in this case could get those documents slightly earlier. That was all I was raised. I've canvassed that with my learned friend for the police, and they are taking instructions on that. So I don't think it's anything I need to trouble my lord and my lady with. But yes, we would be happy with that. The compromise will mean, I hope, very much hope, the fact-finding will go ahead, and that's what the Guardian wanted.
Yeah.
But as to the wider issues, I leave that to the court as to whether they want to look at wider issues or not.
Right. All right. Ingrid, you want to
My lord, might I make this just slight
Yes.
submissions? And sorry, because it's just important from my client's perspective that point. The dates weren't proposed as a pragmatic solution because the chief counsel's, and my lord, I can understand the line that you're taking, but from the chief counsel's perspective, there is a judgment or a decision, an order refusing PI in relation to material which the judge, as with the chief counsel says, is entitled to material. If we go forward, for example, and if for whatever reason the interview data is provided as the chief counsel says that it will within the next 2 weeks, and the parents refuse to attend or are unable to attend or proves whatever, for whatever reason it proves impossible to complete the interview within the 2-week period, the police will then still be left with a judgment in relation to which PI has been refused and which will form the basis of any subsequent consideration by another judge in relation to PII.
Why do you say that?
Well, because you won't have quashed it.
Well, this judgment isn't going to be. I'm not in any way endorsing your criticism, but this judgment isn't going to be on bail or published.
No, but in this case, you will have a judge who said, PII, I've looked at PII, it's refused for these reasons.
Well, I think the proposal is, as I understand it, that the order will be set aside on terms and replaced by the new order, or varied, replaced by the new order. So the order which was made following the hearing would be set aside, by whatever means we decide to do it.
But would that, well, the Chief Constable's concern is that if this matter and the PI issue has to come back before the court in the context of these proceedings, the Chief Constable, as has been explained in the appeal, considers that the PI assessment that's been undertaken is flawed, and the Chief Constable is very keen for that assessment, or not to be the starting point or relied on subsequently in these proceedings if a PI issue arises.
The circumstances will be different if you are back before the court, because you will then be in a position where the parents are resisting attending an interview.
My lady, I'm not saying that the circumstances won't be different, but given that the Chief Constable has appealed this decision on the basis that it's flawed, the PI assessment, insofar as the Chief Constable is correct and it is a flawed assessment, then that assessment should be quashed and it should form no part at all of any subsequent consideration of PI in these proceedings. Whilst the Chief Constable would be able to say, oh, things have developed since then, nevertheless, the starting point would be this assessment by this judge. And if it's the same judge that's hearing a PI application by the police, then insofar as the judge applies the same approach that she applied here, that is a matter of great concern for the police. So what I tried to suggest was really an answer to your question before lunch, my lord, which was, are we saying simply quash it and send it back down, or are we saying quash it and then the court can then proceed to look at it?
But if the appeal proceeds, Mr. Payne, it is possible that you won't succeed, in which case you'll be stuck with the order that you've got at the moment.
Well, absolutely, my lord, and then insofar as that is the order that the court considers needs to be made, then we obviously, we had a stay, but then you in any event are going to have to make direction, aren't you, in relation to how compliance with the order can take place in practice.
So are you saying to us, you're only, this offer that, or the suggestion you put forward only applies in the event that the order is quashed?
My lord, I can't obviously I can't tell the court, this court, how it should conduct this hearing. All I'm saying is that the Chief Constable wishes to proceed with the appeal in terms of the quashing of the judgment. I was asked by my lord, well, what would happen afterwards? And I said I had to take instructions, but we are content for this court, if the order is quashed, to give directions. And in terms of the directions to assist the court in terms of the time frame, this is what my client says they can achieve with the technology that's now available.
But this is what your client can achieve irrespective of whether the judgment is quashed. This is what you have a duty to act diligently and reasonably. And whereas previously you weren't able to say when the interviews would be held, you are now able to give a clear indication that the interviews can be held by the 12th of November. And that's something you ought to do then in any event, whether it's quashed or not.
Absolutely, my lady. I'm not trying to hold anyone to ransom. I'm not saying we will only do this by that day. I mean, my clients, just to sort of perhaps emphasise the point, my clients are well aware of the best interest of children, best speed is of it, all of that. And I'm not saying that my clients will not do that, whatever the outcome.
Well,
but what I am saying, though, is that we have a PI assessment that we say is flawed.
Yes, we understand that.
But it's only an assessment which relates to this specific decision. If there was another disclosure issue, heaven forfend, in these proceedings, the judge this judge, or whichever judge it was, would be obliged to conduct it on a fresh basis.
But, my lord, I mean, I don't want to...
But insofar, I know you're concerned, you've got a sort of wider point about the way in which these issues are being determined generally,
Yeah, and
which we haven't had time to explore.
No, and my lord's indicated that it's not for this court to give wider guidance just like that.
For my part, you've persuaded me at least that this is an issue which needs to be looked at by the President of the Family Division. I should be telling him that and discuss it with my colleagues. I should be drawing this case to his attention. And I imagine lots of things he might do. He might refer it to the Public Law Working Group under Mr. Justice Kean, which would have, that's the sort of forum which should be looking at these issues. Those who are much closer to these proceedings than I am, or we are, this time of problem, on the ground. That's the way I think we should, for my part, how we should deal with any difficulties that are now arising because of this tremendous problem with data.
Well, my lord, I mean, that's obviously, I'm sure my clients will be very happy to hear that. And I had, of course, provided the Supreme Court case of G&G, similar issue, but in that case, the Supreme Court highlighted some issues which the bodies may wish to consider in terms of providing guidance, and set out in the annex. And I understand that it would be held to be very valuable. But just going back to, in terms of the PII issue, any subsequent PII application is going to be heard by the same judge. The Chief Constable's position is this judge approach to the PII assessment was flawed. There is no reason at all to think that this judge won't take the same approach to a PII application.
Well, it'll be different material at a different stage in the proceedings with different reasons for not wanting to disclose it.
With different submissions on behalf of the police, I expect.
But, my Lord, in terms of the approach that's taken to the PII application, it will start from the premise, and if this decision isn't quashed, that the analysis in this judgment is correct.
Why? Why will it start from that basis?
Why
You've got permission to appeal, and the appeal was resolved on terms where the order was varied.
My lady, I'm just trying to understand how, if there is no finding that this decision, this assessment of PI was flawed and should be quashed, what the judge below will have is a decision effectively that's just been resolved on pragmatic grounds with no indication at all as to whether the PI assessment was flawed. So why should the judge adopt a different approach in light of the approach he's taken? So
because, as my lord said, the circumstances will be different, the timing will be different, the submissions will no doubt be different.
Well,
you can't just keep harking back to your last judgment and say, well, that's the result.
Well,
the circumstances are changed.
Mr. Sampson will want to no doubt be reflecting in the unlikely event that happens. He'll put in his written submissions to the judge a line which will ensure that he doesn't end up here again.
well,
I think
my lords, the reality is, from the Chief Constable's perspective, the judge adopted an approach to this application.
We understand that,
Totally
Mr. Payne. You spent all morning telling us why the judge got it wrong.
Then the reality is that if such an approach is adopted to new facts, there is a grave risk of the same flawed outcome being reached.
I think, as I've said already, a difficulty in this case is the way the hearing was crammed into the morning at 9 o'clock. And I think it's a misconception. We haven't had an argument, but for my part, I don't think this is a case management issue. I think PI is a more serious issue. And I think that a lesson which should be learned from this is that PI applications of this sort should be more time and perhaps more care should be devoted to the preparation and longer time in the hearing.
But if this judge then just adopts the same case management style approach to a subsequent PI application...
Well, you're making assumptions about the future. I mean, the fact is that appeals are appeals against orders. The judge's order is going to be discharged and replaced with a new order.
Well, my lord, you've heard my submissions.
We have. Right, what we are going to do is to discharge the judge's order on terms that it is replaced by a new order. The terms of the new order will be agreed between you. We would like a draft by 4 o'clock tomorrow afternoon. If there is any disagreement about the terms of the order, we will rule on the papers. But the bare bones of the order will be that a hard drive will be provided to EM by Monday the 1st of November, that the parents will be invited to interview by the 12th of November, that EM will produce a report by the 15th of November, and the mother will have liberty to apply since she has not formally given her consent to this disposal of the appeal.
Confidentiality. Confidentiality. Anything about not being disclosed to
Yes, yes, I should have said that disclosure to EM is on the basis that it will not, the material will not be disclosed to the parents in advance of their interview.
No order on the appeal. No order on the appeal.
Yeah, well, I said that. So apart from that, there will be no order on the appeal.
Well, can I just correct one? Not correct. Can I just invite just to bring to the court's attention that whilst you were discussing, confirmation that we won't be able to actually provide the hard drive till next Wednesday. So not Monday till Wednesday.
That's the 3rd.
I think so. Yeah.
So that then moves it to the 18th, does it, for the...
My friend has just told me that we're going to make inquiries of EM, but we're hopeful. And I'll also add, if I may, my lord, into the order, the alternative scenario that the colleagues' police force can provide it to us, and then we can discharge the EM order altogether. But it will be on a contingent basis. One or the other.
All right.
And my lord, just in terms of just clarity in terms of what the Chief Constable has agreed to do, it's that once the interview has been completed by the parents, then EM can forward them to disclose the material.
Yes, well, I think between you can work out the nuts and bolts of how this is going to work.
Yep.
And as we know from all the various documents we've seen, there should be cooperation between the various state agencies.
Absolutely, my lord. And just to reassure those sitting behind me, because they want confirmation, that the order obviously discharges any obligation on the police to disclose the closed witness names.
Yes,
No,
I should have mentioned that, yes.
Well, that will be in the order, yes.
Well, if the whole first order...
The whole first order is going, so
yes.
That will not reappear in the second order.
I had thought that's what you meant by just to reassure those instructions that I had.
Yes, indeed.
Thank you very much.
Right, thank you very much indeed.
Do you think we could just do the order together while we're all here, rather than us having any problems subsequently?